needs a lawyer once you have Stephen Gould's Breaking Law to hand? Jon Snow.
You're on?
Oh, so sorry.
Breaking Law is an amusing, entertaining and incredibly useful book. Piers Morgan.
I got carried away reading the blurb on the back of my book.
The Return
of Breaking Law. Some really famous folk have said nice things about it. I'm so embarrassed.
I'm a Radio Times man myself.
Ah, so that gives you a pre-nuptial agreement and a will template, does it? And draft letters, draft court documents and other documents. My time acting for Ron and Reggie Cray and what happened to Ron's brain. Draft...
He is the judge! He is the judge! Everybody knows that he is the judge!
Another improvement in workers' rights comes into force on the 6th of April 2024, which may distract you from the shock that the new tax year starts on that day, so you'll be able to get down to your tax return for 2023-2024.
But the ink has only just dried on my last return.
Ink or blood? I suppose he discloses the fortune he makes from producing these videos. And muckraking in Ambridge. I digress. The 6th of April. The limits to compensation awards that can be made by employment tribunals increase where the axe falls or some other relevant event occurs on or after the 6th of April. Boss, the 5th of April's unlucky. It's an unlucky day for me and I was going to go to the footy tonight. If sack me you must, can you make it until tomorrow? Award limits are increasing by 8.9%. So for an unfair dismissal, the maximum compensatory award, there's a basic award on top, that rises to £115,115. And the notorious 1 week's pay, that's used for the calculation of the basic award and also redundancy payments, that rises to a £700 limit. I've fallen out with a store.
Not Waitrose again.
Oh no, we're best friends again, and their tinned onion soup and Italian chocolates, they're delicious, not if consumed together. No, it's Boots, and it's about the right to a replacement for a substandard purchase. I've got an online account with Boots, and I'm a well-established customer. Their face masks are tasty. I spent £57.83 on an online order for various bits and pieces, including one item for £2.70.
What was it?
Mind your own business. Anyway, when that £2.70 item was delivered, it was cracked to pieces. I immediately rejected it and I explained to Boots why. I was told to return the item at a store or through Royal Mail, free of charge.
Although the price was only £2.70, you had spent nearly 58 quid and were a loyal customer.
I know, but I could have been a loyal liar and pretended the item was cracked to pieces when it was in perfect condition. They told me I could ask for a refund or replacement. That was at the very beginning. So I asked for a replacement and I sent off the cracked to pieces item through Royal Mail and it actually arrived. But I had to nudge Boots about whether they'd received it. And then they told me they would refund the £2.70 and deduct the loyalty points I'd earned on the £2.70 item.
They wanted the loyalty points back on £2.70?
Well, business is business. The upshot was that on top of the refund, they ended up crediting me as a goodwill gesture with points to the value, to me, of a £5. And they justified the points value at a £5 by reference to the fact that the item had only cost £2.70.
What do you say about that?
Well, I say, as I said to Boots, that there's no correlation between the cost of an item and the degree of inconvenience the customer suffers as a result of an item being unfit for purpose. I had to report the unfitness to Boots, organise the return, organise getting hold of a replacement, and spend time in exchanging emails with their customer services department. I thought £5 in the circumstances was too low for points.
So you are taking the case to the Supreme Court, I suppose?
No, I won't be suing this time, but what does concern me is Boots' attitude towards replacement. Despite what they initially told me, they later revealed to me that their policy is not to replace for an item costing less than a £5. But I had a right to require replacement. That's under the Consumer Rights Act of 2015. I wasn't entitled to require replacement if this was impossible, say the product was no longer available, or if replacement would have been disproportionate compared to repair, say because a replacement would have cost Boots 200 times more than the cost of repair. But neither impossibility nor disproportionality applied here. But nowhere does the Act absolve a trader from refusing to replace simply on the basis that it's a low-value item.
So what arguments did Boots put forward on the law?
Well, none. And although I've written to their head office and press office on the matter, they're not responding to me. Let's hope they change their policy. Around 4,200,000 people across the UK provide care for an elderly or disabled member of the family or dependent. They are unpaid, and the majority are women over 50 and often have to balance a job alongside the care. The 2023 Carers Leave Act allows them what will usually be a maximum of 5 days unpaid leave a year from their job where there is a long-term care need. The right to normal annual leave and flexi-working, that won't be affected. What the Act intends to target is planned and foreseen caring situations rather than emergencies. And if the boss wrongly refuses this new leave or does something to their workers' detriment because they've taken it, the boss can be hauled up before an employment tribunal.